My name is Susanna Baruch. I'm the Executive Director of the Petrie-Flom Center for Health, Law, Policy, Biotechnology, and Bioethics. A very long name because we do a lot of things. I'm delighted to welcome you today to How Old is Too Old to Govern? Before I turn this over to my friend and colleague, Professor Shen, I just want to say a couple of words. This is our 20th anniversary year. I hope you got our special 20th anniversary swag. It is available next to the water over there. You can grab a multi-tool and a screen cloth on your way out. We are grateful for support from the Oswald D. N. Kamen Fund at Harvard University, and I want to say I am grateful to the Petrie-Flom team, Laura Chong, Lisa Grelick, who is outside, and Erin Lynch, for making all this happen with unfailingly good humor. We hope you will check out the Petrie-Flom website, our blog, Bill of Health, and subscribe to our newsletter. So to get us started, Eleanor Roosevelt once said, "Today is the oldest you have ever been, and the youngest you will ever be again." People around the world are living longer. That includes our elected officials and our judges. And as the Petrie-Flom Center explored in our annual conference last June, a conference that will become a book next year, published by Cambridge University Press, we are witnessing new scientific understandings of the aging brain and body and the impact it has on law and policy. So I want to say as just a table setter, today's event may feel a little bit ripped from the headlines, and I want to be clear that our center is committed to approaching this topic with empathy and with scholarly rigor as we think about aging, health, and the law. We, for many years, have had a joint project on law and applied neuroscience with the fantastic Center for Law, Brain, and Behavior at Mass General. Their executive director, Dr. Kinshirf, is in the front row here. They have terrific groundbreaking resources on aging and elderly fraud protections. We will also be putting on, with the Harvard Law School Project on Disability, an online event on November 18th discussing older persons' human rights, the United Nations, and the connection to the rights of persons with disabilities. Today we hope you will hear from our panel why aging while governing while aging is still a very significant and unresolved issue, and some of the options for addressing it. So I'm going to get out of the way and turn this over to Professor Francis Shen to introduce the panel and lead today's discussion. He is Professor of Law at the University of Minnesota and a member of the Harvard Medical School Center for Bioethics. He is also the founding director of the Dana Foundation Career Network in Neuroscience and Society, and absolutely most importantly, a former Petrie-Flom Senior Fellow in the Project on Law and Applied Neuroscience. So I'll turn it over to Francis. Thank you for helping us organize today.
Yeah, thanks, Susanna. Thanks to everyone for being here. Thanks to Professor Cohen and all the Petrie-Flom staff for always making these events so easy to organize and on such timely topics. So first, we're going to introduce our panel. Each of us will talk for around 5 to 7 minutes, which will then leave the bulk of the time for discussion and your questions. But let me do our introductions first. I'll talk first. Susanna mentioned I'm a law professor, but I work at the intersection of neuroscience and society, and questions around aging in the law are quite of interest. Our second panelist will be, you see him down there, Dr. Silverman, and we'll make Dr. Silverman big when he talks. We'll speak second. He is a psychiatrist, a professor of psychiatry and faculty member in the Harvard Medical School Center for Bioethics. He's director of ethics at the McLean Institute, Biotechnology and Psychiatry at McLean Hospital, and he's the senior IRB chair at Mass General Brigham. He's worked extensively around the ethical and legal implications of advances in technology and psychiatry, and we've worked together a number of years around aging brains and the law's issues. Our third panelist today probably needs no introduction, but I will give you one. Judge Nancy Gertner is a senior lecturer on law here at Harvard Law School, also a retired federal judge. She was appointed to the bench in 1994 by President Clinton, won numerous awards, but my favorite to mention is in 2008, she received a Thurgood Marshall Award from the American Bar Association section of individual rights and responsibilities. She was only the second woman to receive that award. Justice Ginsburg was the first. She's written widely on many legal issues, civil rights, civil liberties, criminal justice, employment. You should read her book if you haven't, In Defense of Women, Memoirs of an Unrepentant Advocate. And for students, she teaches here regularly, including around sentencing, and she introduced the first law and neuroscience class in the nation right here at Harvard Law School. She is also a big part of the Center for Law and Behavior at McLean. So thanks, Judge Gertner, for being here. So my job is to set the stage, and I'm going to do so in about 5 minutes. As I mentioned, I work at the intersection of neuroscience and law. Our motto of our lab is every story is a brain story. I think this is certainly true, but there are two caveats, both of which will come into play today. The first caveat is that every story is not just a brain story. It's a story of politics and culture and history and all those other disciplines that law engages with. And secondly, and this will come up in just a moment, every story is not a fully understood and at times not well understood at all brain story. And that uncertainty about what's happening in the brain, today that uncertainty about what's happening in the aging brain causes some real legal and political challenges. The issue we're talking about today, I want to echo what Susanna said, is not about any one person. We held this same sort of event back in 2017, Dementia and Democracy. And the timing, 8 years later, we still have the same challenges. Could have done the same event during the last administration. The issues we're talking about today are not about one person. They're about changing demographics. They're about changing cultural understandings and changing science. And I want to start today with where I left off 8 years ago. I don't know that anyone was here then, but my point was I went through all of these headlines where, then it was Speaker Pelosi, or it was Harry Reid, or it was this person, that person. Oh, they've got this, they've got that, without any actual data. And I said, well, surely we can do better than rip from the headlines. And the question today is whether we can. I don't think we're doing that yet. 2 data points. One, and there are many other ways to categorize this. This is from a New York Times article earlier this year. You can just look at the trend lines. There are more people in Congress who are older than there were before. 2 reasons for that. One, everyone in general is living longer than they used to a long time ago. But crucially, there are a subset of jobs for which people don't hold retirement parties. In most industries, you don't see graphs like this. Why? Because no one wants to keep working. In fact, everything they're doing is trying to figure out when they can stop working and spend their time on the beach. But as Benji and I, we had this lecture series that we've been designing on aging professions. So lawyers, professors, judges, politicians, physicians, CEOs, owners of sports teams, national leaders. These are places where people don't want to retire. We could talk about the reasons for that, which leads to this conundrum and this sort of data. What can we do about this? Well, one option, I'll give you a couple, is to impose age limits, and there are some polls that show there's some public support for this. Would require a constitutional amendment.
Can't see the titles of your slides. It makes it hard for you to grab because of that green and red.
Okay,
Yeah, we
well,
may not be able to do that.
I think you can hide that down there a little bit. But the main point is that one thing you can do if you've got a concern about aging adults is you just have a bright line rule. And they do this at FAA around airline pilots. We do this in the majority of states. So there are mandatory retirement rules for state judges in the majority of states. That's one way you can do it. The upside of that is administratively very easy. All you need is a birth certificate and a calculator. The second upside is you reduce, though not entirely, but certainly reduce some concerns about cognitive decline in older ages. The primary deficit of this approach is you lose all of the wisdom and you don't individualize at all. And that's one reason I don't like it, but that's very possible. The scientific challenge is that We know a lot about how groups change over time, and by the way, at the beginning of life, how they develop. But at the individual level, and Dr. Silverman is going to talk about this, the science of aging is not so well understood, which is why you can go online and be befuddled by a gazillion supplements. All of them are going to tell you they're going to help you live longer and have, cognition and memory forever, etc. My favorite example of sort of age is just a number is my friend Flo Myler. She is 90 years old. We both compete in track and field to this day. And she does all these things. This is just from the last year. Pole vault, hurdle, throw the javelin. An age-related, comment is simply that people age really differently. They age differently in terms of cognitive development as well. So one other solution is to require cognitive tests as a precursor, as like if you don't have a certain score, you're not eligible to participate. I think there are some real concerns about that. Again, it's unconstitutional. You'd have to get in there and change things. But things have been proposed, and I'll skip the details, but that's one other option. My favorite option is to have mandatory disclosure the way that we have mandatory disclosure of financial information. The basic idea why we require financial disclosure is we say, hey, you got this, we don't phrase it in this way, your information processing machine is going to make decisions that affect the jurisdiction in which you're in. We think that the way that you've arranged your finances might affect the way you make decisions. Like, hey, big company gave you a lot of money, maybe the way that you handle that bill will be affected by that. And so we disclose it, and you can then decide as voters, hey, that's a big deal to me, no, it's not a big deal to me. It's constitutional, it's withheld constitutional scrutiny. And my view is that one way to handle the topic we're talking about today is to require a cognitive assessment that would not be threshold, you can score anything you want and still be elected, but would be additional information that voters could then have amongst a package of things they may consider. And there are many examples where they may say, you know what, that's not a big deal to me. For these other reasons, what I want in a politician is something else, or I respect their 30 plus years of service, and I'm going to vote for this person until they decide that they don't want to run again. So that's what I do. Think about what you want to do. But whatever we do, we need to think about the underlying science and the question of what would an assessment actually look like? How do you know at all whether someone has a form of dementia or not? And I'll transition to Dr. Silverman to help answer that question with this comment. It's ripped from the headline, so there's no slide about it. But this morning, Governor Pritzker, I guess maybe last night in the news story, commenting on deployment of National Guard troops in Illinois, said this direct quote, speaking about President Trump, "This is a man who's suffering dementia, something in the recesses of his brain that is effectuating him to have to call out these cities." Governor Pritzker, accomplished man in many ways, certainly not a medical professional. This is the sort of headline that we've seen again and again on both sides. And again, it raises this question, Dr. Silverman, that I hope you will help us answer, which is two related questions, and anything else you want to comment on. If you had a perfect world and you were able to sit with someone, how do we actually make these assessments? And then, since we're not in a perfect world and we don't have access to this, how do you as clinicians, as you are looking at politicians, what is your role in public discourse about commenting or not commenting on individuals who you observe in public, but you don't get to assess as the way you would your patients? And with that, let me hand it over to Dr. Benji Silverman.
Thanks so much, Francis. There we go. Thanks so much, Francis, and thanks so much for allowing me to join virtually. I really wish I could be there in person, but I had a field trip with my 3-year-old today, and they were gracious enough to allow me to do both events, so I appreciate that. This is such a fascinating topic, and I'm going to try to just give a few comments in response to Francis's kind of prompts, and then really look forward to hearing from the group kind of what you're thinking about this and what your reflections are. So just to start, just to kind of add a little bit to where Francis started, I think it's worth just saying briefly talk briefly about how the brain ages, right? So everyone's brain ages. As we get older, we tend to have slower information processing, slower efficiency of information retrieval. And this is normal, and it doesn't typically interfere with our ability to kind of do our jobs or any other type of regular activity. And really, as Francis kind of outlined, there's profound variability. So although we know at a population level, age is associated with things like medical morbidity, given his friend that he showed, at an individual level, the age is just a number and really can be quite misleading. Um, Pathological brain aging, so beyond kind of the normal aging brain, can also occur in many different ways. We see people who have, some sort of small decline in their cognition. They end up meeting the threshold for what we call, a mild cognitive impairment, and then they plateau and they stay there the rest of their lives. Other people have a very gradual impairment that in a somewhat linearly but progressive way eventually leads to full-blown dementia. Other people have specific events. They have a stroke or a brain injury, and they have kind of a stepwise progression of their cognitive impairment. And then the impairment itself can also be incredibly heterogeneous. Speech, language, recognition, recall, executive functioning. There's just a huge mixture of the way in which the brain can malfunction essentially. And the one kind of hallmark is that when we do talk about pathological aging versus normal aging, it is usually accompanied by some sort of functional impairment, although then we're left with trying to define what that means. So there's really kind of two fundamental problems. One is that there's not one process or one disease that we're looking at. And then there's enormous individual variation. So, Francis provided the example of superagers. I think the problem with individual variation is really highlighted when we start thinking about people who govern, in that when we think about people who govern, they tend to be above average intellectually. They have above average baseline neurocognitive functioning. They often have high socioeconomic status, often have high educational attainment levels. And all of these things essentially create what we've referred to as a high cognitive reserve. So cognitive reserve is essentially the ability of the brain to adapt to insults. So the ability of the brain to cope with or compensate for either age-related changes, normal age-related changes, or pathology. And that occurs through a whole variety of different ways that we won't get into here right now in terms of the neurobiology, but basically the ability of the brain to recruit other areas of the brain to help out is a very kind of forest to the trees view. The other piece to that is actually there's a practice effect to that. So lifelong engagement in high cognitively demanding occupations like governing or high intellectual pursuits like academia actually increases your cognitive reserve. And so really this problem of individual variation and cognitive reserve is really amplified in kind of the populations that we're talking about. And so what does that mean? That means that, what I like to say is when someone has full onset dementia, when they can no longer recognize the people around them and their loved ones, and they can no longer take care of their activities of daily living, we can all recognize that it's actually fairly obvious to everyone. When you have a high cognitive reserve, subtle forms of cognitive impairment are going to be less obvious. So by the time it becomes obvious through public observation, the underlying disease may actually be quite advanced. Just as kind of a nuance there, the other problem I think in the context of governing is there's a little bit of I'll use the phrase pseudo-competence that can occur where you're not operating alone. You have tremendous support from teams of people around you who are helping you with your functioning. And so your ability to function may seem higher because of that, and maybe more difficult to assess. So there's a lot of complicated factors at an individual level about how cognitive functioning, displays itself. So then, with all that said, moving to Francis's question around, so then what do we do? How do we assess that under optimal conditions? Really the biggest challenge to assessing cognitive impairment is lacking a baseline assessment. So most of us do not have a baseline assessment, right? So most of us have never had neuropsych testing before. As we get older, if we display some sort of, cognitive challenges, someone might say, let's do some neuropsych testing. But without the ability to compare that to something, without being able to see a trajectory, it's really, really hard to know what to do with it. So under optimal conditions, we would have a baseline and periodic, formal neuropsychological assessments. And we can talk about what that is, but it's a neuropsychologist, is a specialized form of a psychologist who sits down and uses standardized tests to measure someone's neurocognitive functioning. That can sometimes include academic tests. It can sometimes include occupational testing, depending on the situations. But in the absence of so ideally you have a baseline and you'd repeat that, I don't know, every year, every 2 years, every 3 years, and you'd be able to follow the trajectory over time. That's going to give you the best picture of someone's cognitive status. In the absence of baseline, we rely on norms. And the problem with norms is basically what we were saying before, is that the problem of essentially outliers, which I think many people who govern are outliers. So if you consider the example of someone, for example, that has a baseline IQ of 160, right? So they have a baseline IQ of 160 their whole life, which is exceptional, right? Off the charts. And then you go and do neurocognitive testing on them after they've had some sort of problem, essentially, and they score 110. What does that mean? 110 is well within the average range, but it would actually represent a catastrophic decline for someone like that. And so a 1 point in time compared to norms is actually very, very unhelpful, especially in this population. And I'm talking about full neuropsych testing. What we often hear about when you hear, stories in the news about people getting tested is often more abbreviated screening tests that I think are even less likely to detect problems in someone that has a higher cognitive baseline. A key feature to many of these assessments is collateral history. So we often get history and information from family, friends, coworkers, teachers, medical providers, everyone. That's, of course, incredibly challenging in the situations that we're thinking about for people who govern or in the public eye. Informants may not be willing to come forward, or they could come forward and actually provide misinformation. Another really important thing to note, and this ties in a little bit to where we're going, is that these assessments require willing participation by the individual being assessed. So there's obviously varying levels of cooperation. Some people like really cooperate and give it their all and really want to kind of get the best score possible. But there has to be at least a desire to sit down and a willingness to sit down and answer some questions. And neuropsych testing can take, 6, 8 hours. It can occur over the span of days to weeks. And so it requires a commitment. There's not, unfortunately, there's not like an MRI machine or some sort of other objective device where we could just put someone in and it gives us their objective functional neurocognitive status. And then the final thing I'll say about testing is the testing also doesn't necessarily mimic real world situations, right? So especially faced by those who govern. So testing often occurs in an office, a quiet office without other distractions, where you're sitting down one-on-one with someone and going through this. How does maybe after you've had a good night's sleep and after a good meal, how does that compare to, for example, being, in the situation room in the middle of the night, dealing with a national emergency where you're getting thousands of incoming information streams? I'm not sure that the comparison is actually that meaningful. So I'll wrap up by just saying, answering the second question is what can we as clinicians say from afar? It's a really tricky question. We spent a lot of time on that. What I'll say is, traditional bioethics basically says we can't say anything, right? So people have probably heard of the Goldwater rule from the American Psychiatric Association. Essentially says it's unethical for psychiatrists to offer a professional opinion about a public figure's mental health without conducting our own personal examination, without obtaining authorization, et cetera. We can talk more about that. I have lots of personal opinions about that. I'll suffice it to say, I do think that, from a very utilitarian standpoint, I think if people have expertise that could benefit the greater good, I don't think they should be prevented from using that expertise as long as they can do so in a, somewhat objective and non-biased manner, which perhaps is actually the real non-starter there. We have seen, and I think this is a very interesting thing to think about, an increase in the use of publicly available language samples to comment on people's neurocognitive status, something that in some fields like speech and language pathology, it's actually a standard approach, language sample analysis. So like a standard of care kind of assessment of people's speech. And for neurocognitive status, we know that cognitive changes do manifest by language. And with new machine learning algorithms, we can kind of, get an almost unlimited sample of someone's speech. And it's actually very easy to see the appeal potentially of that approach. But I think there's a lot of limitations and cautions to think about. Speech samples can be rehearsed, they can be read off a teleprompter, they can be written by someone else, they can be impacted by factors we don't know about, how much someone slept, if they're drunk, if they took medications that either could help their cognitive status or impair their cognitive status. And then perhaps most complicated is with the growth of AI and deep fakes. It's hard to know what's even a real or not real speech sample at this point. So that's kind of my thoughts on what we can say from afar. And then the last thing I'll say just about the suggestions that Francis made, I think I look forward to talking about them. The idea of doing cognitive testing in some way, of course, would face all of the same challenges that I just kind of went through. So we'd have to think about, what does that mean in the context of a policy in terms of the reliability of assessments like that in this specific population. And the final thing that Francis has heard me bat around before a little bit is another area that I think a lot about, and probably because I'm a physician, is I wonder sometimes about if we can pull this into the world of mandatory reporting in some way. So physicians are mandatory reporters. If we learn about some sort of information that could be a risk of harm to someone else, we have an obligation to do something about it. And that obligation to public good essentially outweighs our duty of confidentiality or privacy. So for example, a drunk school bus driver comes in to see me, I'm required to notify people that there's a drunk school bus driver. And so one might ask the question if a physician is treating someone who governs and has reason to be concerned about their cognitive ability, does that not create some sort of obligation to the health of society that would overrule privacy and require some sort of reporting? There's a lot of question marks there in terms of how you define harm, and it's often kind of diffuse and speculative and delayed, and it's not a specific harm, and who do you actually report it to? And then there's a slippery slope of how far down on the governmental ladder does that apply to? So there's lots of questions, but it's just another lens to potentially think about this that I wanted to kind of raise. So I'll stop there and look forward to more discussion.
Thank you. And Judge Gertner.
Yeah. So I feel like beginning with the poem, I only can remember a little of it because after all, I'm old. When I'm old, I shall wear purple and learn to spit. That's all I remember of it. I wear red. We'll avoid the spitting for now. So let me look at it in 2 ways. We have focused, it seems to me we've laid out 2 paths here. One is a categorical path and one is an individualized path. Categorical is a term limit or a retirement age. And the individualized path is what Dr. Silverman was talking about, which is some kind of individualized assessment. And I want to look at both and critique it from the perspective of a former judge. I might say that I retired at 65, not because I was doddering, although some may have said I was, but for 2 reasons. One is I didn't want to end my career as a judge feet first. Seemed to me not an elegant way of going out. And I also felt young. I felt like I had another round. I had more things I wanted to do other than judging. It was an unusual decision. Very few judges actually in those days made this kind of decision because being a judge is an easy way to go old. You have, young clerks sucking up to you all the time. You have litigants sucking up to you all the time. People laugh at your jokes when they're not remotely funny. And so it was very unusual to do what I did, not for the purpose of making money, but for the purpose of just wanting another round in my life. So let me start with the categorical issue, which we've talked about. So in some respects, the retirement age is both over-inclusive and under-inclusive, right? It's over-inclusive because it could very well include those who are not remotely impaired. And the best example of that is Judge Edward Weinstein in the Eastern District of New York, who retired at 95, still churning out scholarly and interesting opinions on a variety of subjects, speaking, writing. There was nothing remotely impaired about him, or perhaps relative to the rest of the bench, he might have been impaired relative to the way he had been, but certainly not relative to the rest of the bench. So It is over-inclusive because it could include people who are not remotely impaired. If there had been a 65-year-old age limit for me, I would have had a conniption fit if someone told me to retire at that point, because again, there was nothing about me at that point that was impaired. It's also under-inclusive because it obviously could include those who in fact are younger but impaired. So the rule would be both over-inclusive and under-inclusive. So what about the notion of an individualized test? I am discomfited by an individualized test because the measure is not cognitive decline, because there are value judgments in the measure of what comprises cognitive decline. For example, and I don't know whether any cognitive test includes this, there is something profoundly troubling about having a bench that is largely in the ages of 50 and whatever, who are dealing with technology. I mean, I can tell you, it's not an issue of cognitive decline, it's a question of having absolutely no sense of the internet world, of the technological world. One of the judges of my court famously was appalled that we were talking about mice in the building, right? When I went on the bench in 1994, I was the only judge in the building who turned on my computer, let alone used it. So the individualized markers may cover some issues of decline, but I'm not sure, we don't talk about sort of whether or not it covers issues of experience, issues of what it's like to be a judge for 50 years and then have no relationship to the outside world, or very limited relationship to the outside world, and therefore limited relationship to technology. I might say, for some reason, I don't understand why I actually love the technology. I was playing around with email one day in the middle of a proceeding. That was very boring. I would be on email to communicate with my clerks when an issue was coming up, but I made the mistake of the AOL was still on at that point, and when you clicked on it, it says, "You've got mail." And it said that very loudly to everyone in the audience, and that was not fun. So I worry about what, if we don't have an agreement on what comprises cognitive decline, I'm not sure that I feel comfortable about a cognitive test. We know the end point. We know dementia is cognitive decline, but the intermediate points, as Dr. Silverman was saying, I'm not so sure we know how to identify. Again, there's the example of Judge Weinstein. One of the judges of my court was in obvious decline, and it is incredibly difficult to convince him that it was time to go. There's a famous case of Judge Pauline Newman, who was in her 90s, and essentially people moved against her to get her removed from the bench, and she had sued the court, claiming that the process of identifying her impairment was not transparent, was not subject to values that we all share, and we don't know where that is going. What was the reason why the court moved against her? Well, there were people who said that she was harassing staff. You understand that talking about harassing staff or having, some meltdown on the bench is one thing. If you're telling me that my dissents comprise cognitive decline, boy, that would be another issue. In other words, what is the marker of individualized decline? In our divided world, in our incredibly divided world where judges are under attack, I worry about the theme of judge being too old and the extent to which it undermines the legitimacy of the bench. Judge Bill Young just issued a decision last week finding that the Trump administration was withdrawing visas and green cards based on speech. And he wrote a very strong, very, very strong opinion saying that non-citizens who were in the category of the people before him have First Amendment rights, And he went through in great detail the ways in which the Trump administration was undermining those rights. And then there was an ending piece when he was asking the question, what do I do about it? And there was perhaps 10 pages that began justice in the age of Trump. And one can certainly disagree with what he said and the context in which he said it. There are people who agreed. But what was interesting to me is that the social media immediately went to Judge Young is 84. So the age issue figures into a discussion which could delegitimize the bench. Having said all of that, over-inclusive and under-inclusive categories, individualized testing, I do believe in a retirement age. I do believe in a retirement age, precisely in order to avoid these debates and to take the risk of categories that may, in fact, lead to very well-qualified people leaving the bench. I stand for a retirement age, or particularly for the Supreme Court justices, because I believe not only an issue of impairment, it's also a question of democratic legitimacy. And that relates to my point before about the technology. There is another generation coming down the pike, which is different, represented in this room. And if the retirement age should address both the issue of cognition, but also the issue of democratic legitimacy. And there should be a change in the bench. Now, of course, I would have been excluded from that because I'm on TikTok, Instagram, Blue Sky, Substack. I love it. I get nothing done, to be sure, but I absolutely love it. So, I mean, I think that a categorical rule makes sense because we really don't have any other decent measure. And then I'm going to learn to spit.
Would you, for politicians as well, if you could amend the Constitution, set aside the procedural possibility, let's say you could, would you also put an age limit for politicians?
Probably not, because their age figures into a electoral process. You see, for judges, once you're in, you're in. In other words, that discussion can take place in an electoral setting. With a judge, it doesn't. So I think, I certainly with the Supreme Court, and I think once if we do it for the Supreme Court, we would do it for the lower federal courts as well. Age limits and term limits are discussed with the Supreme Court, and term limits actually, I believe, can be implemented without a constitutional amendment, where you have, I wrote about this in a piece on the Brennan Center website, where you have a judge take senior status, stay as a judge, but take senior status, and his responsibilities or her responsibilities change. There would certainly be debate about whether that's constitutional, but I do think that it would be, and that would be an interesting way to proceed.
Should we open up?
Yeah. We're happy to run mics to anyone who has a question. Starting here.
I think this is a super exciting topic. I guess two observations that I'd like you to respond to. One is for politicians, of course, we already have minimum age gates to become qualified. So it seems like a much smaller bridge to cross to add a maximum as well if we're going to discriminate on age. But the second thought is I know anecdotally that some law firms and some law schools have mandatory retirement ages. I wonder if, does anyone have any systematic data about that? How common is that? What are those ages? I just know literally a handful of anecdotes from major firms and major law schools.
I don't know the data. I know that the majority of large firms have retirement ages in Massachusetts. So I don't know, and with respect to universities, there is something analogous to senior status, where you can take an emeritus position and your responsibilities change, but you remain a professor. That doesn't work with law firms, but I mean, someone should study that.
I guess of counsel would be the potential analogy.
Right, but again, I mean, I think that, I know people who are forced to retire, who are then, with respect to lawyers, you're forced to retire from your firm, and then you open a small firm and you continue to work. So it doesn't work with judges. I can't have to, well, I do private judging.
Arbitrators,
so
yeah.
Arbitration is private judging. And my colleagues in arbitrations are usually even older than I am, which is extraordinary.
I could just add to that quickly that the same thing happens in medicine. So there are places where surgeons, for example, have an age cutoff where they're no longer allowed to do surgery, but then exactly as Judge Gerson said, that they can just go somewhere else and practice surgery.
Thanks for this presentation. This is super interesting. I hear your comments about the problems with the blanket approach, but also the issue with people's different individual levels of cognitive ability. And I'm curious, I have some apprehension about applying mandatory disclosure for cognitive tests for politicians, both based on the idea that I know there's some analysis of things like IQ tests having cultural bias. And also I have some fear of like something like, probably not as bad as, but like literacy tests for Black voters and how there might be bad actors or just unintentional harm done to people by these tests and bias from people looking at them. And I wonder if you've put any thought into how that might be mitigated in some way, or whether you think voters will be getting incorrect information based on bias from tests.
Yeah, I don't, Ben, do you want to talk about that for a sec, or the assessments themselves and their...
Essentially, the short answer is yes, that's a concern. You know, that assessments can be biased. You know, some assessments require more interpretation than others, but you know, just like what we know about SAT scores and things like that, you know, that there is going to be some inherent bias, and obviously that's one detractor to that. You know. Solutions to that are very tricky. I mean, you can validate assessments in different populations.
Yeah, I guess I'd add to that I take the point. I think none of these assessments would be perfect for sure, but that in the absence of that, unless you have a bright line rule, and speaking specifically for politicians, I'm very concerned that you have a vacuum. You have nothing. In fact, all the incentives are to not disclose, and more than that, actually to create a public persona that would mask. I mean, I think the Biden administration example would be like the most prominent example, but there are many other examples, and it happens at lower levels as well. I think actually one way to do that is to stage it so that before it were public, it would be an opportunity for an individual themselves to make their own assessment. So one of the interesting data points is that individuals, on average, not everyone, who are suffering from cognitive decline, in some ways are the last to know. And with judges, there's good data that it is very hard to get someone to off the bench because for a lot of reasons. What I proposed for judges was that it's actually all private. It's never public. I think that's a different group. But that they be informed as well over time. It'd be their choice. For politicians, I do feel differently. But I guess the other thing would be voters can completely ignore it. It's not a threshold. It's not a litmus test. I think there were many at the end here of Senator Kennedy's days where he was, not the lion that he once was, but forget it. Everybody still wanted him, man. Probably would have wanted him too. So we can choose for a lot of different reasons. In the same way that financial disclosures, okay, you got tons of investment here. Some people say, who cares? But I think it's an excellent point. These, and to be clear, they're not perfect tests. The assessment is in the eye of the court.
I would like to also look at to take your point, what the cognitive tests encompass, because judging is more than just, can I add up a column of figures? Judging had to do with experience and indeed this je ne sais quoi of judgment. So I'm not sure that maybe if my arithmetic abilities lapse, that doesn't necessarily mean that from my experience I don't understand what a credible witness is. I don't have that kind of judgment. So it would be interesting to see how sophisticated these tests could become, but I doubt very much if they could capture what comprises judgment. I mean, I got on the bench after 20 some odd years as a civil rights and criminal defense lawyer. And I had a wellspring of experience, which stayed with me and which mattered to my judging. And so even I suppose if I were in my 80s when I continued to judge, that wellspring still mattered for something. So I just worry about how we judge cognitive impairment, particularly in judges.
I'll just add one last quick thing, which is that in 15, 20, maybe fewer years, we can have a discussion about the actual machinery, the neurobiology, which is why I love neuroscience so much, because all of our discussions today and all these assessments are, as Dr. Silverman said, mostly behavioral. What do we observe? And then we're going to infer something about the circuitry, the way cells are communicating. All of the efforts elsewhere on this campus are to understand the underlying neurobiology that gives rise to things like judgment and thought. And last thing I'll say is that ABA, ratings on potential judges are in some ways making inferences about brain activity as well. How well can someone know and apply the law when someone says they're vastly unqualified? It's not that they don't have a brain, it's that the way their brain has developed and is processing, says the ABA, would be that, well, when they see a case, they're not going to be able to, apply the law correctly. Great question.
I'm hoping this is on. I have a question sort of in two parts. One of them, I appreciated the analogy to campaign finance, that it's a disclosure. Unfortunately, the other part of that analogy is that while the American public might really badly want elected officials to do something about campaign finance reform, generally the friction of actually getting that legislation passed or that new standard written is because it does not serve the elected politicians who would have to create it well. And so therefore, nothing happens even though the American public is in agreement they would like something to happen. So I'm curious how you would see a vehicle to actually operationalize any of these solutions actually passing. My secondary question has to do a little bit more with individualized testing. Are you concerned that would create some sort of legal precedence for an expected lack of privacy around a person's health status generally? I'm thinking about if I'm running and I find out I'm pregnant a couple of months before the election, do I have to tell everyone? Is that something that might be a result of saying that there are certain facts about my health that are no longer private?
So the second one, I think, is for me straightforward. Is the question, does it affect the function of the job that one is setting off to do? And there are many, many types of health-related issues that have no bearing at all on the function, from the issues with knees, pregnancy, to a whole bunch of things I put in a bucket of no. But then there are a whole bunch of things that I think would matter. So at an extreme, a terminal I'm running for an office, it's a 4-year term, I get a terminal diagnosis. Nobody knows it except for me, and I know that I'm gonna die in 9 months. I think that's a much more difficult question. And then to me, we are electing someone because of the way they process information, how their elbows work and their shoulder and their knees and their thighs, who cares? But the main thing they're doing is taking their sensory organs, listening, hearing, engaging the world, processing that information of central nervous system, and making decisions about what to do. So the closer we get to that, that would be the types of stuff that I think would be hopefully just voluntarily disclosed because we'd want to know. And I think, again, we don't use those terms, but when someone says, you want me when the phone rings at midnight and I pick up the red line, what they're saying is, you want my brain when I hear what is told through my ear and I get that information based on all the things that I've done in my life and the way that my brain functions, to make the right next call, and that's the beauty of neuroscience and law. We don't talk like that, and of course we don't know at present what that looks like in a president's brain, but I think eventually will. So that would be the answer to the second. And to the first, of course, it's difficult. I would say that at the congressional level, I think there has been progress made in terms of congressional disclosures. That doesn't always happen. Doesn't always happen as much. But there is an ethos, I think, where certain things are generally required and disclosed. But I take your point. None of this is.
Except also, Francis, I rankle when you talk about judging as processing information. I mean, because it's not, as I said, because there is a je ne sais quoi, which is judgment. So I pick up the phone at, pretending I'm now the chief executive officer, and it's a question of processing information, but it's also a question of making normative judgments and so it's not a processing issue exclusively, it is a judgment issue, and that could be impaired, but I will look forward to a neurological test that will enable us to capture judging and judgment. I do think that particularly now, there may well be a movement to have age limits Certainly, I think age limits or term limits for judges, because as Francis said, they exist everywhere else in the world and in the majority of states. So the Supreme Court's lack of an age limit or a term limit, either one, is really unusual. I do think that the analogy to the fact that to having an age limit to run for office at the lower end suggests that there may be openness to coming up with age limits at the upper end, and that would be interesting. That would be interesting. Whether or not current generation of octogenarians would vote for it, of course, is another question. I'm not yet an octogenarian. Just want to put that on the record here.
And there may be other reasons for term limits that are really important, or mandatory retirement ages, which I'd agree with. So even if someone is functioning extremely well, you might just say, for the reasons you mentioned, Judge, we need new faces here.
I'm going to jump in to ask a question. I think of Dr. Silverman. You mentioned the Goldberg rule and the concern about not having outside professionals try to evaluate people, maybe in the public eye. It strikes me that we have all kinds of organizations rating and essentially judging candidates, nominees on all kinds of grounds. And I wonder, it sounded like you maybe think there could be an opening for a little more of outside evaluation being a relevant piece of information for voters or for policymakers to decide on judges. But I just want to give you an opening to talk about your thoughts there.
Sure. No, it's a great question. I'd love to hear what other people think too. You know, I think it's really, really hard because, you know, I think part of the reason that people say we shouldn't do it is because you don't actually have what you know to be factual information that you're making your judgments off of, right? So as I alluded to before, you know, you may be making judgments off of things that may not even be real these days because of AI and deep fakes. You may be making judgments based off of, you know, one clip that you got after somebody, you know, took a medication to help them sleep. You may, on the other hand, be making judgments after someone, you know, used a psychostimulant that's going to help their cognition, and then had a incredibly well rehearsed, you know, performance. So it's really hard, I think, to make judgments when you don't have kind of like your firsthand information that you're kind of gathering with your own eyes and brain. And kind of as the judge said, you know, our job is a lot of making judgments also, you know, the art of medicine rather than the science. And so it's really hard because you don't, you know, it's kind of the garbage in, garbage out thing, that if you put bad information in, it doesn't matter how expert you are, it's hard to know. And then, you know, I think there's some arguments that are made around just like the trust in the medical profession, the sanctity of the medical profession, all of that kind of thing. And that, you know, most of the time people who are taking the choice to make these public proclamations, it has more to do with their political leanings and more to do with their personal beliefs. And so that's why I said kind of like, I think if you could do it in a way that was truly objective and non-biased, I think I'm of the belief that if we have expertise to share, we should share it with the world. But those things may just be non-starters in the divided world that we live in today. But I think it's really tricky. I guess my basic perspective on it is, I don't like the fact that we just shut down the conversation by saying, oh, Goldwater rule, we're not allowed to do that. And it becomes very kind of just like line in the sand. I think it's much more nuanced and worth discussing more, kind of as I alluded to, and as Francis alluded to, you know, that there is a role for people with this expertise, I think, you know, in the public discourse, but how we kind of accomplish that is tricky.
Thank you. We are in a room in which a class will start in 15 minutes, so as to avoid being trampled and pushed aside, I think this is a wonderful time to thank all three of our panelists and say